it, folks. So, okay. So, what we're going to be covering today, and it doesn't want to progress. Oh, I always have fun, don't I, with slides. Okay. Right. So, what I'm going to be covering today, I'm going to do a little bit about me because there's a couple of people on the call that don't actually know me. I know some of you do. And then we're going to look at Join the Triboo. Lovely name for a business. And I'm calling it a game of three halves, if you can have a game of three halves. We're going to look at who they are. So how they came to the attention of the ICO. We're going to look at the law and the timeline around this, and then the original findings, because the original fine was actually issued last year in 2023, and then it went on to the tribunal this year. So when it gets onto the tribunal, we're going to look at the grounds that Join the Triboo used to try and defend themselves against the incredible £130,000 fine that the ICO had implemented. We're going to look at how the ICO responded to their appeal, and then what, excuse me, what the appeal findings actually were at the tribunal. Can then move on to what makes consent valid and look at the interplay between PECR, which is the privacy and e-comms regulations, and the GDPR. So I hope everybody's heard of both, but don't worry if you haven't. We're going to look at the ICO's view on these and how to make sure you get your own consents right. Going to touch on the soft opt-in. If you don't heard of that, don't worry. I'm going to be covering what that is and who it applies to. And then just one slide on business to business marketing. So I know I've got a mixture of business and charities on the call. So a little bit about me then. So I started doing data protection scarily nearly 24 years ago. The background to me getting into data protection was I worked for a government agency who should have received a couple of discs, and this is going back a bit now, so not floppy disk quite, but discs with 250,000 families details on from HMRC. The discs got lost in the post basically, and it led to a complete shake-up of how the civil service at that time dealt with information security and data protection. So my career started in data protection really in the public sector until about 2010-11 when I moved into the charity sector. And at that point, and last year, as Michelle will know, technically I retired. And I do what you do when you retire. I went off on my first ever cruise to Alaska. I got back, and then after about 6 weeks, the day I put daytime telly on, I thought, no, babe, that's enough. You've got to do something. So I set up the Data Protection Lady. And something you don't know about me is I'm also Granny Bev. So let's move on to Join the Triboo and who they were. So they've been around since around 2010. So they're quite a well-established company. They're primarily an online recruitment firm, but if you look at their company's house registration, it says their business is web portals, information service activities, and advertising agencies. But I say primarily in the recruitment area. Now, it was really interesting how the ICO came to learn about them, because the ICO were actually investigating another company, LeadWorks Limited, in 2020. So this obviously does date back a fair bit. LeadWorks Limited were fined by the ICO for sending unsolicited direct marketing. And we're going to look at regulation 22 of PECR later on. So don't get hung up on the numbers or the regulation numbers. We'll be looking at the principles behind them. So LeadWorks Limited told the ICO when they were asked, where did you get the ICO asked, where did you get all the data you were using for this direct marketing? And they said, we got our data from Join the Triboo. So, of course, at that point, the ICO had never heard of them, and Join the Triboo was sourcing that data from the websites they were operating. Now, So the ICO very quietly and surreptitiously started an investigation into Join the Triboo's websites, and I'm going to go into those in a moment. But what they discovered was these websites, 4 out of the 5 websites they were running were very similar, shared the same consent statements, the same privacy statements. And that started ringing alarm bells with the ICO about how they were actually obtaining their data. So let's move on to it then. So, little bit of playing detective here. So, as I said, Join the Triboo were running 5 different websites. Now, 4 of these websites, as I said, were predominantly around job advertising and recruitment. 3 of those 4, which is where it all gets fun, it just says something like, I agree with marketing, yes or no. And this is just taken straight from the tribunal findings. So it said, by entering into the website, obviously, you agree to our privacy policy and to receive communications by email, phone, and SMS from whoever. So they'd linked their privacy policy to this, so people, if they wanted to, could go and review the privacy policy. So on the 4th website, which wasn't using the same consent statements, it says that basically you agree to receive offers by emails from, now this is where it gets interesting, on behalf of selected companies that we believe will be of interest to you. And then it gives these broad definitions, automotive, retail, finance, yes or no, do you agree to receive these offers? So they were giving a broad description, and again, privacy notice was linked. Now, these websites, by the way, I said there's one called UK Job Search Online. These had 200, this one, just the one website, had 262,000 registered users. So they'd have all gone through this consent statement process. One called UK Job in a Click had 171,000 registered users. I love the titles. Find a Job Anywhere, which had 13,000 users. And then Job for You, which had 9,000 registered users. Now, bizarrely, the 5th website that they were operating, nothing to do with recruitment whatsoever, and was called Savings Direct, which had 3,500 roughly users registered. So going back to their statements, they had statements like, I agree, or I do not agree. By entering, you agree to receive communication by email, phone, and SMS. So what then becomes interesting is all of these 5 websites all linked to the same privacy notice if somebody actually clicked the link. So let's look at that not the whole thing, obviously, but let's look at the, take the segments from that all-important privacy notice. So in that privacy notice, it confirmed that Join the Tribunal carried out email and marketing services. They've been pretty transparent there. And that they carried out these services for third parties, and then actually said in any business sector, and they referred to these as business partners and clients. So what they're effectively doing is something called hosted marketing. They've got the people's data, the company who want to get their advertising in front of individuals, say to Join the Tribunal, this is the demographic, this is the type of business sector we're in, can you send out emails on our behalf? So as you just saw, it gave 11 very broad categories of the type of partner that they work with, like financial services. But then interestingly, in 9 of these 11, so you have to start playing detective again, there were a further subcategory in 47 of them saying like you'll get offers or surveys or things like that. So there's a lot of digging, really, if you want to understand and be informed about what is actually happening with your data. And then there's an interesting and very broad statement. So with your consent, we may share, rent, and sell your personal data, or sell or rent our entire database. And if you think the numbers of people we're talking about, so 262, 362, we're close to 500,000 people there, rent our entire database to our partners and clients for any commercial purpose, including marketing activities. And they're not actually naming those partners and clients at this point. So by marketing activities, we mean the communication directly to particular individuals by post, telephone, SMS. So that's the sort of the statement that they were relying on to make their business activity compliant. So I hope it's all making sense so far, because people are putting things in the chat, I can't actually see it. So when the ICO started investigating, this is what they tried to argue, that people had to subscribe to receive direct marketing. So they weren't just taking data, they were actually having statements. They tried to argue that their registration process has two separate checkboxes: one to receive direct marketing, and one, consent to transfer that data to the third parties contained in the privacy notice. But let's just think a minute. That privacy notice is just giving a description of the individuals, of the individual businesses, not actually naming them. So the privacy notice was linked to the sign-up page, but let's be realistic. How many people actually, where the privacy notice is linked to a sign-up, actually go off and read it? So the checkboxes weren't pre-ticked, so they weren't acting in contravention of PECR or GDPR there. And people could still actually register on these sites if they didn't tick the boxes. So it wasn't a condition of using the recruitment websites that you had to tick the boxes. So they were trying to argue that people had a genuine choice about what they did. So this is where you're going to need to get your phones out. And if this works, there is a QR slide coming up on the next page. So if you can get your phones out, and that one person on there already was me testing it out, can you either go to slido.com and put in that hashtag code, or scan the QR code? And this is obviously completely anonymous if you haven't used Slido before. I won't know who is saying what, but so far, do you think that JTT was compliant? So we've got yes, unclear, and 60% saying no. Okay, so people are saying yes and no, or it's unclear. And I'm going to say, I think we will never know if JTT were actually trying to be deliberately obstructive. And we'll talk about bundle consents and transparency and clarity later on. So I want to add a bit of context before we go back to any more little quizzes like that. So let's add some context. I'm going to put some numbers into this. So across those 5 sites that they were running, 459,000 people had registered across those sites, of which 254,000 had opted in, with that double opt-in perhaps. Now, during the period August 19 to 20, so going into COVID, interestingly here, they had run 40 email campaigns in a year on behalf of 26 different companies. So this is not doing it for themselves. 26 companies have gone to them and said, we need to get our marketing in front of this demographic of people. So for those 26 companies, they'd run 40 individual campaigns. And as I mentioned earlier, this is hosted marketing, i.e. it's sending the marketing on behalf of those companies to its own distribution list. Now, in that time, so in that year, they had sent almost, and this is a big number, but 108 million emails in that 1 year. And you might think, well, that's an awful lot, but that is to 437,000 people, individuals. So I worked it out. That's roughly 244 per person over a year. Now, 244 is roughly 4 to 5 a week, so maybe 1 a day. Now, I've definitely seen this sort of level of targeted marketing with other organisations, including some charities. So when you might think those numbers are huge, when you break it down to maybe one a day, it's not an uncommon practice in sending that many out. So on a positive note, they were really good at managing people who opted out. So they didn't carry on sending emails to people. If someone hadn't opted out, they didn't. And somebody who hadn't opened an email in the last 12 months was also opted out. So again, that's good practice. So the interesting aspect I want to throw into the mix here is that the ICO did not receive a single complaint about JTT ever in the last 10 years. Now, I think that's quite interesting, and we can perhaps look at that a bit more in a moment. So, given what you now know in terms of, let's go on to the original findings, sorry. So, the original findings of the ICO at that point, when they actually issued their monetary penalty notice, which is the fine. And in case you don't remember, that fine was £130,000. So they argued that JTT had breached PEC Reg 22. So what is PEC Reg 22? The ICO is saying that they hadn't ensured that valid consent was obtained. And valid is the key word, actually. So for consent to be valid, and I know there's at least one DP person on the call here, so obviously, you know, valid consent has to be informed, specific, and freely given, and an unambiguous indication of that person's wishes. So the ICO was saying they violated PEC Reg 22 because they didn't meet another area of GDPR. And this is where the interplay between GDPR and the PEC regs start to come into play, because if you're going to get consent has to meet GDPR standards. So that definition I've given you, the informed, specific, freely given, and an unambiguous indication of someone's wishes falls under GDPR Article 4, Section 11. So this is where it does get a little bit heavy, folks, sorry. But I will be sending the slides out afterwards. So if you really want to dig into all the lawful basis, if you're not a data protection person, you can. If not, just take the general meaning from it. So Article 411, freely given, specific, informed, ambiguous. So the ICO said, now this is basically about the soft opt-in, which is an exemption within PECR. So I'm sure a lot of people don't realise, and it's an exemption. It's just not another aspect of PECR. It's actually an exemption to it. And that exemption basically says, as an example, say I bought a pair of trainers online, then the company I bought the trainers from can then legitimately start sending me direct marketing without me opting in, because I've engaged in a sale with them. And the same tends to apply if, say, I put those trainers in my basket online but didn't actually buy them. Well, that would be counted as the negotiation of a sale. Now, the ICO basically said this exemption, or the soft opt-in, did not apply in this instance, because the email recipients, although they'd signed up and opted in, weren't buying anything. So I think that's quite an interesting approach to take. Now, this is, where we start to think, is it fair and proportionate? Because in the ICO's view, this was a deliberate act on behalf of JTT. So that what they're saying is they set out to deliberately confuse people and not give them transparency on what they were doing. And in saying it's a deliberate act, the ICO said to them in their findings that they should have known. They're a business. The ICO has a lot of published guidance on PECR on their website. So it's no excuse that you're busy running your business and you can't go out and find what you're supposed to be doing. So the ICO also said they did take account of something that JTT did after the investigation has started, and that JTT brought in a legal company to help them. So again, that are they trying to do the right thing, or is this a deliberate act to mislead somebody? And the ICO did say that they would take into account the impact of a fine would have on Join the Tribunal's business. Now, I did go to Companies House and look at their filed accounts, because and the last accounts were 2022. So if you look at their profit and loss account for that year, their turnover, yeah, it looks big, £1.5 million. But their profit for the same year was £36,000. So, before we go on to the next bit, I just want to say that again, as part of that very first PEC Reg 22 breach, the ICO also said that consent to non-specific third parties, so our trusted partners, carefully selected partners, doesn't meet the standards of informed consent. They're not being informed. So if you are an organization that buys data lists, how informed, my question to those sort of companies is, how informed was the person who gave their consent? How did they know what type of organization their data would be shared with? So profit, turnover of 1.5 million, profit of 36,000. That technically makes them an SME, a small business. But this is what happened. The ICO imposed that fine of £130,000 on the 12th of April last year, and they basically gave them 2 weeks to pay it, which I nearly fell off my chair when I saw the timeline they gave them to actually pay that fine. So phones out time again. So in knowing what you know now about Join the Tribunal, the fact that they brought in a legal firm to help them, they were asking people to do the double opt-in, they observed people when they opt out or they stopped engaging, and this is really subjective, do you consider the fine to be fair and proportionate to their business? Maybe. Yep. No, interesting. And I think this is where it gets really subjective. I've worked with a couple of lead generation companies recently, and they think that they thought they were doing the right thing. So I think this is really interesting about how as a business, what is your level of understanding about these things? And the ICO's argument, it doesn't matter. There's guidance out there. You should know it. You're responsible. So I think this is quite interesting when you start looking at it from a business perspective. So, my little thingy isn't working. You can't, that white circle you're seeing should be me appearing on camera. So it obviously doesn't want to work when I'm doing it through Zoom. So that's the end of chapter 1. Now, it won't surprise you that Join the Tribunal appealed the fine. And I think most business, I think in the getting 2 weeks to pay £130,000, I'd fall off my chair as a business if I received a fine of that nature. And I know I haven't put it on the slides, but literally something's just popped into my head. Where you have your business insurances, do they cover if you get fined by the ICO? Some cyber insurances do, but I think it's something that businesses might have to start looking at, because I know when you take out your professional liability, professional indemnity, public liability, your cyber insurance, do you actually read the small print for something like, if you get fined by the ICO for a breach of PECR or GDPR, does your insurance cover the fine? And I think the ICO fines more for PECR than it does for GDPR breaches. So it's something to perhaps as a takeaway, go and have a look and see what your insurances actually cover you for. So I'm just going to take a sip of my smoothie, folks, because my throat's kicking in a little bit at the moment. Just give me a second. Okay, right. So let's look. So obviously, Join the Tribunal appealed the fine. And this went to the first tier tribunal. And for those of you who don't know, there's 2 levels of tribunal. There's a first and second tier. This is the result of the first tier, because the first tier tribunal only published the results in May this year. Whether they're going to take it to the second tier, I don't think anybody knows at the moment. They could, but it obviously takes time, money, and effort to take something like this to tribunal. So they took it to tribunal. So in short, this is a 50-page document. I'm starting to proceed down here. In short, they tried to argue that they hadn't contravened Reg 22, which, don't forget, is the around the lawful direct marketing. They said their opt-ins were specific. And this is where it's got interesting. They tried to say the ICO had wrongly interpreted Article 411, which is the consent has to be freely given, specific, informed, and an unambiguous indication of someone's wishes. So I thought that was quite an interesting challenge back to the ICO. They tried to argue that the ICO hadn't contextualized the sign-ups and that people knew what they were signing up to. But if you reflect on, the ICO has already said, well, if people have only got this broad description of financial services or whoever they're signing up to, the ICO is saying that can't be informed. So interesting argument coming out here. They said, and this is Join the Tribunal's appeal, that the fine should not have been issued because the conditions for it being a serious fine were not met. What they actually said was that the conditions for it to be a serious fine, does it cause a serious risk of harm to those individuals, a financial harm or an emotional harm or a physical harm? They argued that the conditions for that fine weren't being met. They said it was marginal at best because there was no damage or distress being caused to the individual. And of course, there's been no complaints. So what are they basing this argument that it's a serious issue and a serious fine? Join the Tribunal tried to argue that there was no material impact on someone's right to privacy as this, and to say that it was insufficient for the ICO to say that they should have known what the law said. And I think that's quite interesting here. They're basically saying, we're a business, we don't have time to know what the law says. So they then said that even if the ICO had that discretionary power to issue the fine, it applied its discretion wrongly. So they went on to say, you're getting into deep water here with the ICO here, saying the ICO had applied its own policies wrongly. Because what they were saying is, in the actual detail, the ICO is they're saying the ICO has basically asserted that Join the Tribunal was not a legitimate business. They tried to argue that the fine was disproportionate because they'd brought in a legal firm to help them, and that the fine and the reputational damage as a result of this fine was caused enormous damage to the business and probably terminal to it. Now, every now and again, I do go into company's house and see if they're still functioning as a business. And at the moment, the company is still there. So it does make you wonder whether or not they are going to take this to the second tier tribunal. So that was their appeal, basically saying, dear ICO, you've got it wrong. We are a good business. We do what we're meant to do. How, as a business, do we have time to go away and research all the pages you've got on your website to get it right? So this was what the ICO came back and said. So they basically restated that a request for consent has to be prominent in a plain and clear language and separate from your privacy information. So it's got to say what people are actually consenting to. So we're getting into a bit of a tit-for-tat argument here between Join the Tribunal and the ICO. Join the Tribunal saying, well, people did know what they were consenting to. There's been no consents. How can you argue that people didn't know? Now, the ICO said from case law, and for those of you who don't know what case law is, this is where things have gone, like this case itself, has gone through either the courts or through a tribunal. So it's taking what the ICO is saying as law and their guidance and testing it as a case. And so the ICO argued from case law, they were saying that if you don't know what you're signing up to, that consent is basically invalid. The ICO said that even if someone has to tick the box to say they do want to receive the email, it doesn't reduce the burden or invasion of privacy. So they're saying it doesn't matter if someone ticked the box, it's still an invasion of their privacy if they don't know what they're signing up to. Now, this next bit is about those third parties that data had the potential to be shared with, because there's no definitive list of people. And I think this next point is really, really interesting, where the ICO said it's not enough to rely on a list of sectors or a list of particular companies buried at the end of a privacy policy. Now, I see this a lot. Especially where brokers are selling lists of data recipients to organization. And when you look at the wording that someone has actually seen in a privacy notice, it may say something as generic as, we may share your data with, and then list financial institutions, automotive institutions, housing institutions, charities, and it doesn't specify who any of those organizations are. So for the ICO to start saying it's not enough to rely on a list of sectors, I think brings a really interesting dynamic to this case. And the ICO went to say that their welcome page and registration pages were at best ambiguous as to whether or not it was possible to register without consent to marketing activity. Because, and again, you still see this on people's pages, although people have to tick the boxes to opt in to receive emails or to have their data shared, remember those original opening statements, the bottom of the form says, by entering, i.e. joining the website, you agree to the privacy policy and to receive communications. So you've got this balance there. Somebody may not have opted in, but how are they interpreting that statement by entering onto the website? So I think it starts to get quite interesting. So at this point, I just want to summarize the violations before we move on to the detail that came out in the tribunal. And I hope your heads aren't all spinning. I did say this was a bit of a text-heavy session. So what were the consent issues that were coming out? So basically, it's inadequate to have third-party consent where it just says selected partners, whether they're carefully selected partners or business partners. So the consent was not specific, informed, or clear regarding who that data was going to be shared with. The poor practice in terms of opting in for third-party marketing was the automatic inclusion of third-party without explicit consent, that by continuing to enter to the site, you are agreeing to it. So that again breached the GDPR because the consent wasn't specific or informed. And then the lack of transparency around their data sharing practices. They had that really broad statement at the very beginning that said we might share or rent out our entire database. So they were saying that breached the GDPR Article 13 about the transparency requirements. So I've got a slide coming up. There's a lot of words in it. I'm sorry, but this is the sort of the specific GDPR. So this is a high level summary, if you like. We're going to go on to the specific GDPR and PECR violations next. So Article 411, as I said, the conditions for consent, that freely given, specific, informed, and an unambiguous action on behalf of the individual. So their consent mechanisms didn't meet those standards. Article 7, which backs up those GDPR conditions for consent, where it says, interestingly, the data controller must be able to evidence or demonstrate that the data subject has consented to processing of his or personal data. So that's basically something that links to your database. Can you actually show that on a certain date at this time, Bev agreed to her data being used for that purpose? And over time, your wording for your opt-ins is bound to change. Your privacy notice is bound to change. So best practice was also say, link what Bev has signed up to the words that were put in front of her at that time. So Article 6, the lawfulness, if the ICO is arguing that the consent is valid, then all those that the consents didn't meet GDPR standards, then none of those consents were valid. I've touched on Article 7 already. The recitals, for people who don't know what the recitals are, the GDPR is broken down into two areas. You've got all the articles. So like I'm saying, Article 4, Article 5, they're telling you what you do. The recitals tell you how to do it. So the GDPR is broken down into those areas, the what and the how. So the ICO, well, the tribunal found that they had breached the hows, the recitals 32, 42, and 43 specifically. So 32, again, links back to that clear affirmative action so that the consent was freely given. Everybody's going to know this little phrase off by heart by the end of this. The consent was freely given, specific, informed, and an unambiguous indication of someone's wishes. And that is through a written agreement, and that includes electronic means. So the ticking the box, which is why you can't use, which is why you can't use pre-tick boxes anymore. So the ICO has also said the tribunal found that silence or pre-tick boxes or inactivity doesn't constitute consent. So it's got to be that positive action. And again, we're going to talk about bundled consents in a moment. Where the processing has multiple purposes, the consent should be given for all of them. So if the data subject, that's the individual's, consent is to be given following a request by electronic means, the request must be clear, concise, and not unnecessarily disrupted to the use of the service. And I think this is where it gets interesting. On the one hand, the ICO is saying that consent has got to be for each individual area. And then the flip side, they're saying, but it's got to be concise and it's got to be, mustn't be disruptive to someone engaging in that service. So recital 42 there, and this is what they call the burden of proof for consent, is where the processing is based on the individual's consent, you've got to be able to evidence that consent. So when and where and how and what wording did Bev give her consent to? And then recital 43 is that the consent cannot be presumed to be given if it does not allow a separate consent to be given to the different personal data processing operations. So again, you've got this dichotomy between having specific consent for different aspects of processing, whether that's receiving marketing, or it could be sharing data with someone else, as in this case, or if you're a charity, it could be doing an event or volunteering, and that to be balanced against, but it's got to be concise and mustn't be disruptive. And then the last bit, and the biggest bit they were fined to, is this regulation 22, that the soft opt-in didn't apply, and there was no opt-out of marketing at the time the data was collected. So now this is a bit word heavy, I'm sorry, but this is the wording lifted straight from the tribunal. So this is basically, as you can guess, they probably they did lose the tribunal. So from section 73 of the tribunal, that the tribunal found that the consent will not be informed if someone doesn't know what they're consenting to. And so the tribunal said organisations should always therefore ensure that the language is clear, it's easy to understand, and not hidden away in the privacy notice. And they said that, as I put there, the consent will not be valid if individuals are asked to agree to receive marketing from or on behalf of similar organisations, partners, selected third parties, or other similar generic description. And that's my emphasis in there, because again, I do see this. I see it an awful lot. So within, again, that section 73, the consent statement, and it gave a list of websites that JTT were using, simply stated, I agree with marketing activity. So the tribunal upheld that it was not specific and doesn't inform individuals as to what marketing activity is going to take place, regardless of the means. So the privacy policy stated that marketing may be carried out for third parties who may operate in any business sector. So again, it's saying you can't generalize like that. And then section 78 was about the conclusion from the tribunal that Join the Triboo failed to take reasonable steps to prevent the contravention because they should have familiarised themselves with the law and what PECR and GDPR actually say. They went on to say that they could have consulted with the ICO guidance, or they could have gone to the ICO themselves, or they could have brought somebody in, as they did eventually, brought in a legal firm to actually work with them to get things right. So, another little quiz. Oh, perhaps not. Perhaps not. Yes, there is in a second. Sorry. So, this is more about you. So, and again, you don't be afraid because this is anonymous. I haven't got a clue who's saying what. To what degree do you consider that your business or organisation is compliant with PECR and GDPR, having heard what the ICO and the tribunal have said? And you can be perfectly honest, you know, even if you haven't got a Scooby, that's fine. Some tweaks, some issues. Oh, no one's saying I haven't got a Scooby. Oh, interesting. Okay. And say it's completely anonymous. I haven't got a clue who's saying what. But I think when I talk to clients, I also talk about people's appetite for risk, because in working with companies like a lead gen company I've been working with, when I started work with them a while ago, they weren't collecting any consents. They didn't want to collect consents. And I did go through this case in detail with them. And I did persuade them to put an opt-out in at the time people were signing up with them. And because that is their risk appetite. Their risk appetite, we're a lead gen company, data is all our business. If we ask, they trialed it for a weekend and asked people to opt in, and 50% of the people didn't opt in. So they then wouldn't put an opt-in in place. And that comes down to risk appetite. So we're on the final countdown now. So how do you make sure your consents are valid? And I'm going to have to speed up a little bit if we want any questions. So I mentioned bundled consents. So these are non-compliant marketing aspects, not necessarily from Join the Triboo. So bundled consents. So a poor statement around by continuing to use our services, you agree to our terms and receive marketing information. So bundled consents are not, you know, the general issue is around recital 32. People are consenting to a broad spectrum of things, not necessarily specific, but then you've got to balance that against the need for it to be concise. Occasionally, I still see pre-tick boxes. Not so much these days. I think that sort of concept has got out that you can't do pre-tick boxes, but I do see it sometimes. So a pre-tick box asking someone to untick it does not constitute valid consent. A very broad statement of what's going to happen with somebody's data. If it's not specific, you're not going to meet those transparency requirements in the GDPR. And the implied consent basically disappeared when GDPR came in. There's no such thing as implied consent anymore, because consent has got to be a positive action. So, but there shouldn't, but it probably is occasionally, by downloading this free resource, you agree to receive marketing updates. It's not consent. So what makes consent valid then? So just a general reminder that most of the rules in PECR only apply to unsolicited marketing. So if someone actually comes to you, and if you've just got a blank box on your website saying, Do you want to sign up to my marketing emails or my newsletter? If someone takes a positive action, that is solicited. So it doesn't apply if it's solicited. Consent's got to involve that positive action, that unambiguous indication of somebody's wishes. Record keeping. Now, when you first start out as a business, I cannot stress enough, if you're just starting out or you're in your early days of being a business, you've got to have a CRM that shows when somebody signs up to marketing, because that CRM should be capturing that sign up. Not all CRMs, though, will capture the wording that they're signing up to. So again, it's linking back. What did Bev consent to? What wording was presented to her at the time? So if I bought a cardigan online and that, when I bought it, there's a privacy notice that's saying your data may be shared with X, Y, and Z, there should be a link between what Bev saw when she bought her cardie and the date and time that she gave her consent. So looking at bundled consent, then there's always an argument as to say, is a bundled consent specific? Does it meet those the granularity requirements? So I just want to touch on the soft opt-in, that exemption I mentioned near the beginning. And I'm going to have to go a bit quicker when there'll be no time for questions. So the soft opt-in, as I mentioned, if Bev's bought a pair of trainers before, it allows a business to market to that individual, or even if Bev only put the trainers in her basket, it allows people to market to them. So so it doesn't apply, though, if you buy a list, and it must give people, if you on that first message, the option to opt out. Now, if you're a charity, sadly, the DP and DI bill didn't go through. And so the soft opt-in that was going to be extended to not-for-profit organisations never happened. So charities and not-for-profits cannot use the soft opt-in. Whether the new government will actually go back to this, I don't know. Now, let's just look at what individual subscribers mean. So individual subscribers, interestingly, includes sole traders and certain types of partnerships, because when we touch on business, when I do my next slide on B2B marketing, you can legitimately email cold to B2B, but how do you know if a business is a sole trader these days, or it's a registered company, without checking them out on Companies House? So the soft opt-in only applies to commercial marketing or for products and services. And I said it doesn't apply to fundraising or campaigning. And it doesn't apply if there's no product or service involved, which was what the ICO was arguing back in Join the Tribunal. They weren't even negotiating. They were just about a product or service. They were just signing up on the job site websites. So let's just touch on business-to-business marketing. So the difference, businesses are considered either corporate subscribers or they're individual subscribers. And as I just mentioned, individual subscribers can be sole traders. And interestingly, as I said, sole traders, you are meant to have consent before you do cold direct marketing to sole traders. And it doesn't apply to corporate businesses. But the reality is, if you just look at someone's website, you don't know if someone's a sole trader or a registered business or not. So you've got two types of lawful basis that kick in then for business-to-business marketing. If someone is a sole trader, you're meant to have consent. If you're using the soft opt-in, you are technically using legitimate interest in B2B marketing. And if under the GDPR, then if you're collecting business contact details, the GDPR does apply. So even though it's a business, so you've still got to have a lawful basis for processing. And people still have to have that option of opting out. So even if you're doing purely business to business marketing, you need to give people that opt-out option. So just wanted to, oh gosh, my throat's going now. Just want to summarise what are the risks then if you don't comply with that combination of PECR and GDPR. So we obviously see you've got a financial penalty you could get, still currently limited to £500,000. I mean, no business can afford the 130, let alone 500, because it's the DP and DI bill didn't go through. Had that gone through, there was potential for PECR fines to increase to the percentage of turnover, whichever happens to be the higher. I think reputational damage is for a lot of organizations the bigger area. If you are fined, or even if you get a notification from the ICO of an intent to fine, it's in the public domain. And then, as with Join the Tribunal, the legal proceedings, they would have had to hire a barrister properly, the compliance audits. Well, that's going to really mess up keeping your business going. And you come under increased regulatory scrutiny, because if you're fined or they do an investigation, the ICO doesn't go away straight away. They will come back to you a few months later and say, how are you getting on? Let's audit you again. So 4 quick steps to compliance. Do regularly audit your customers, your clients, your supporters, to make sure see if you've got any compliance gaps. Make sure your staff are aware, if you've got staff, what's changing, how the data protection law and how PECR works. Excuse me. You can make sure your privacy notice is absolutely clear. Your privacy notice shouldn't be written 5 years ago or still in Latin, especially if you're doing marketing. You've got to keep revisiting it. And make sure you've got a good consent mechanism for capturing people's consent. So last couple of minutes. This is a shameless plug. I have a special afternoon on consent on cookies on the 17th of September. It is a paid-for event. It's £30 per ticket. And it's covering a whole load of things. It's cookies, it's social media marketing, including the Facebook Pixel, CAPI, changes under Google Analytics 4, Google consent policy, which changed last year and most businesses seem not have heard of, and cookie governance. And there is a QR code there for anybody who wants to join it, to say it's a good value for a whole afternoon for 30 quid. And then if you need any support on this, that is me. And I'm just going to stop sharing now, because we might have just a couple of moments for any questions. So has anybody got any questions? I'm just going to...
I think just the thing for me, Bev, is particularly around naming all those individual kind of businesses or organizations of who data might be shared with, and where that may sit, because obviously when you're purchasing data lists, you see lots of them that say your information may be shared with charities, housing. You do see some that are very specific about certain organizations that they may share with, as that are kind of a bit of a subcontractor of holding those data lists. But I wouldn't say it's common practice to name every charity that...
And I completely agree, Michelle. I mean, I know exactly what you're referring to when data brokers sell their list. It's very rare that individual companies or charities are listed, because the business model of the data broker is to gather the data and sell it as broadly as possible. And I think that's what makes this really interesting concept, where the ICO has said it's not good enough, because when you buy a data list, the ICO transfers the risk to the company buying the list to check the provenance of the data. So, say at the moment, this is a first-tier tribunal decision. I think I'm going to stick my neck out. I think the ICO knows the businesses how this works. They haven't got their head in the sands. They know how these big data brokers like Axiom and how they work. Until they take the data brokers to town, I don't think there's going to be an awful lot of forward movement there. But it does mean that an organization buying in a data list that is non-specific carries a degree of risk.
Yeah. Interesting one.
I think it is. I think it's, this was really calling that area to town. Any other questions, thoughts, observations? Too heavy on the text, too much to take in?
I thought it was brilliant. Just enough, just enough to create a to-do list. Thanks, Bev.
Sorry. I think, because I personally think this is a very significant tribunal case, because it impacts so broadly. That it's a lot for people, for businesses to take on. And if you're a small business, especially running your business, you probably never heard of half of this. So I think it is a lot for people to take in. And the argument from the ICO that, well, that's tough, basically, you should have known better. You should have read all our guidance. You should have talked to us, is perhaps not being pragmatic in when, if you're running a small business, how much time do you have to actually do that? So again, that's an interesting position statement from the ICO, that actually saying you don't know is not good enough. Okay, everyone's gone quiet now, and we're just about on time. If you do think of any questions, please yell. If your business is using cookies and you're not on top of your cookie, on top of your cookie statement, or especially the Google consent thing, that's catching a lot of businesses out. Either come and join the afternoon or have a chat to me, because even if you've got a cookie consent management platform, what I'm finding is some of those platforms aren't good enough to meet the Google standards. So thank you everyone for coming. I hope you found it interesting. Happy to take things offline if you need a further chat. And I will